for contentions and
Thank you, my lady. The court has a full list of those who are attending all the parties. By way of brief summary, you will hear firstly from me for the appellant, Secretary of State for Work and Pensions, this afternoon on ground 1, and for the majority of tomorrow morning on grounds 2 to 4. You will then hear from Mr. Delamere for the respondent AT, then Mr. Mitriou for the Independent Monitoring Authority, then Ms. Ward for the Air Centre, and then a reply before we finish by noon on Friday.
Now, we have done a considerable amount of reading. You won't be surprised to hear all of you. Obviously, the various judgments and the skeleton arguments we've also read extensively through the authorities. And we think that your time, Esther, is extraordinarily generous, if I may say so. We would hope that, but we're conscious that you were given the 2 days into Friday and people have made themselves available early and so on Friday and only sat late today, so for which we're grateful to you all. But we would hope that we'd finish the appellant and respondents by close of play tomorrow, given how much reading we've had an opportunity to do, so we don't need to reinvent the wheel.
And we think the issues are relatively narrow.
Mr. Covell doesn't look like he agrees.
Well, I've heard that before. Let's see. We'll obviously, I will go as quickly as I feel able to.
Well, let's look at it this way. In fact, all I'm asking is that suggesting is that you trim half an hour off on Friday morning, which is hardly radical. Yes.
In terms of the document, my lady, you should have core and supplementary appeal bundles. You should have authorities in 3 volumes, and my apologies for the initial absence of tabs and other difficulties with the sidelining which we had identified. There are 1 or 2 additional authorities which you will be handed in the course of my submissions and Mr. Delamere's, but not many. And you should have skeleton arguments from the 4 parties. By way of introduction, then, the extent of entitlement to welfare benefits of migrants from the EU member states has been an issue of controversy, which has given rise to extensive litigation for over 20 years. A right to reside requirement was introduced into Social Security legislation in 2004, requiring that benefits claimants, non-contributory benefits, had a legal right of residence in this country. And that led to claims of discrimination on grounds of nationality and to many other claims, some of which have been included in the bundle, some of which went to the Supreme Court and to the Court of Justice. And in the case of the Court of Justice involving not only the United Kingdom but other member states who had introduced legislation with a similar objective. I want to show the court where the law had got to in this area by the time that the withdrawal agreement was being negotiated and at the point at which the UK left the EU. And we submit that that will be helpful for the court both in interpreting what was agreed to in the withdrawal agreement and also in understanding the significance of subsequent legal developments, and in particular the CG case, which, as you know, was at the centre of the Upper Tribunal's reasoning. So, by way of showing you where the law had got to, and we may well take some of this fairly quickly in the light of my lady's indications, but one needs to start with the Treaty on the Functioning of the European Union, Volume 1, Tab 16, and the article the Article 18 right, first of all, within the scope of application of treaties and without prejudice for any special provisions, any discrimination on grounds of nationality shall be prohibited. Article 20, setting out in short form the basic rights of EU citizens, so 20 paragraph 1 establishing the status of citizenship of the Union, and 22A the right of citizens to move and reside freely within the territory of the member states, 22B political rights, and some others over the page. And then 21, by way of addition to 22A, the right of citizens to move and reside freely within the territory of the member state, subject to the limitations and conditions laid down in the treaties and by the measures adopted to give them effect. And in the treaties, just to pause on that phrase, there are a number of treaty rights for free movement, for example, free movement of workers, freedom of establishment, which are subject to limitations, for example, on grounds of public security, public policy, public health. And so far as measures adopted to give them effect, secondary legislation, the primary instrument which creates residents' rights and imposes limitations and conditions upon those rights, as you would have seen, is the Citizens' Rights Directive in the next tab, 17, where you have some but not all of it. And as is always the way when this happens, not all the provisions which it turns out that we may want to refer to. But let me just show you the highlights of what we have in the bundle. Article 6 on page 250 is the citizen's right of residence in the territory of another member state for a period of up to 3 months. And that was the right which AT exercised in October 2020 and was still exercising at the end of the transitional period. Article 7, then, right of residence for more than 3 months. That right is afforded by paragraph A, workers or self-employed persons, and then subparagraph B, critically persons who have sufficient resources for themselves and their family members not to become a burden on the social assistance system of the host member state. And that's the right for self-sufficient persons. Various other Article 7 rights, but we can go to Article 8.4 on page 254 in giving effect to the requirement of Article 7.1b as to a person having sufficient resources. States may not lay down a fixed amount, but they must take into account the personal situation of the person concerned. We don't have Article 14, but I'll show you that in one of the cases that we'll come to in a moment. Article 16 on 255 is the permanent right of residence, which is acquired after 5 years or after a citizen has resided legally for 5 years, and legally meant whilst exercising one of the rights conferred by the directive. And 257, finally for present purposes, the right to equal treatment under the directive was in 2 parts. 24.1 was a right for all Union citizens residing on the basis of this directive in the territory of the host member state shall enjoy equal treatment with nationals of that state within the scope of the treaty. So as we'll see you needed to be residing on the basis of the directive, having one of the rights conferred by the directive under 24.1, and then 24.2, by way of derogation from that, the host member state was not obliged to confer entitlement during the first 3 months of residence, that's the Article 6 right, or where appropriate, the longer period provided for in Article 14.4b, which, as we'll see, is the right for job seekers to carry on looking for work in the host member state. Now, with that introduction in terms of legislation, the first of the cases I want to show you was Dano, which is in Bundle 2, tab 39. This is a Grand Chamber ruling, and you get the basic facts from the head note on 942 of the bundle at letter E. The case concerned Romanian nationals who had resided for more than 3 months but less than 5 years in Germany. The mother didn't work. She and her son were supported by her sister, applied for benefits by way of basic leave for job seekers, but the application was refused on the basis of national legislation which excluded from such benefits foreign nationals whose right of residence arose solely out of the search for employment. So their right of residence in Germany was not good enough under German law to give them the benefits that they sought. Now, there are 3 points that I wanted to draw from Dano. At page 970, the court judgment begins, and the first point that I wanted to take from it is at 982 in paragraph 61. And this is the point that the Article 18 treaty prohibition of discrimination is given more specific expression in Article 24 of the directive. And indeed Article 4 of a separate social security regulation which was being considered. And that meant that a claimant for equal treatment had to bring themselves within Article 24 and couldn't fall back on a more general prohibition in Article 18. So Article 24 governs, that's the first point. The second point I get from paragraph 66 onwards, and the point in summary is that a person must be residing in accordance with the directive, exercising a directive right within Article 24.1 in order to claim the right to equal treatment in Article 24.1. And that is the ruling which is to be found in paragraph 69 of the CJU's judgment. And you'll see the second half of that of the sentence, only if his residence in the territory of the host member state complies with the conditions of Directive 2004/38. And the reason why member states were only going to be required, or could only be required to provide equal treatment to migrants who were residing in accordance with one of the directive rights, and just pausing there, that of course excludes people who didn't fulfil the self-sufficiency right conditions and had no other right. The reason for that is explained in paragraph 74. To accept that persons who do not have a right of residence under the directive may claim entitlement to social benefits under the same conditions as those applicable to nationals of the host member state would run counter to an objective of the directive, see recital 10, namely preventing union citizens who are nationals of other member states from becoming an unreasonable burden on the social assistance system of the host member state. So you've got to be residing in accordance with the directive to claim equal treatment. And paragraph 81 is the finding that these particular claimants were not residing pursuant to a right under the directive, and therefore they didn't qualify for equal treatment. The third point then that I wish to get from Dano begins at paragraph 85 on page 986, and that is the issue of whether the Charter of Fundamental Rights, and Articles 1, 20 and 51 relied on there, whether the Charter could be relied upon so as to provide the right to welfare benefits which the claimants sought. And the Court of Justice reasons that the Charter could not be relied upon for those purposes. And the reason for that is expressed in paragraphs 89 to 91. And the reason was that in laying out the conditions for grant of special non-contributory cash benefits, see paragraph 91, and the extent of such benefits, member states were not implementing EU law. So it was open to Germany in that case to provide that this particular benefit was not available to people with the type of residence right that these claimants had. It wasn't implementing EU law, and so the Charter did not come in to supplement the directive. So that's Dano. More briefly, Alimanovic in two tabs further on, tab 41. The essential facts in this case, again at the top of the head note, the applicants were Swedish nationals who'd come to Germany. Mother and eldest child found temporary jobs which lasted less than a year. After becoming unemployed, they received various benefits, but then benefits were withdrawn on the basis of the same German legislation as had been an issue in Dano, which excluded from such benefits foreign nationals whose right of residence arose solely out of the search for employment. And two points I wanted to take out of Alimanovic. The first one is at 1055 of the bundle. And this is the essentially the point which had been decided in Dano as to the circumstances in which Article 24 of the directive could be invoked, and that's the question that's posed in paragraph 51. Where the court says it's necessary to determine, following Dano, whether the principle of equal treatment in Article 24.1 is applicable, and accordingly whether the union citizen concerned is lawfully resident on the territory of the host member state. I just pausing there. There's something of an objection in my learned friend's skeleton to our use of the term lawful residence in relation to AT. It simply means, and it comes from the Court of Justice case law, it simply means residence in accordance with one of the rights in the directive or some other EU right. And the court answers this question: were they residing in accordance with the directive? Differently from how it had answered it in Dano, paragraph 56. These particular claimants did fall within one of the residence rights under the directive, namely Article 14.4b. But being within Article 14.4b, see paragraph 58, they were then within the derogation in Article 24.2, and you'll recall the principle of equal treatment in Article 24 doesn't apply to people exercising the Article 6 right and the Article 14.4b right, so they were excluded for that reason. There was then consideration, and this is the second issue or the second point that I take from this case. There was argument based on an earlier case of Brey, B-R-E-Y, which the Air Centre in particular relies on in this case, as necessitating some individual assessment of the particular circumstances of each applicant, as opposed to their assessment on the basis of social security rules. And in paragraph 61, the Court of Justice essentially says this is a bright line rule situation, as we might have called it in the human rights context, by enabling those concerned to know without any ambiguity what their rights and obligations are, criterion referred to in the German law and indeed in the directive, during which the right to social assistance is retained, is consequently such as to guarantee a significant level of legal certainty and transparency. No need for any individual assessment beyond what the rules said. The third case is then the Mirga case, which is the Supreme Court, tab 43 of the same bundle. A judgment from early 2016 in two cases, and you'll see the essential facts of the two cases in the italicised section of the headnote. A Polish citizen, that was Ms. Mirga, who had not acquired the right to reside under the workers' registration scheme for migrants from the Eastern European newly acceding countries to the EU, and she was refused income support. Whether the national legislation excluding EU citizens from social assistance benefits, despite such benefits being available to nationals of the host state, was in breach of treaty rights. So whether the right to reside requirement was in breach of treaty rights. And Mr. Samit was an Austrian citizen who had sought homelessness assistance from Westminster Council and been refused again on right to reside for right to reside reasons. Two particular points I wanted to take from this case. The first point begins at paragraph 41 of the judgment of Lord Neuberger at paragraph 1100. Sorry, page 1100 of the bundle. And this is in fact a single judgment of the court, the other justices agreeing with Lord Neuberger. So on 1100, Mr. Drabble's first contention, paragraph 41, on behalf of Ms. Mirga, is that as she is a worker, albeit one whose work has temporarily interrupted owing to her pregnancy, Article 21 of the treaty accords her the right to reside freely within the EU and therefore within the UK, and that the denial of income support to her at a time when she needed it in order to be able to live in the UK was an impermissible interference with that right, as she would in practice be forced to return to Poland. And pausing there, the reason I say this particular point from Mirga is important is that it was central to the reasoning of the Upper Tribunal in this case that the grant of, or the decision on whether AT should be granted universal credit was one which went to the effectiveness of her right of residence. It was necessary to make that right of residence effective, is what my learned friend argues in a passage I'll show you in due course. Now, this is not a new argument, is my point. Very similar argument made in Mirga, Mr. Drabble saying, my client will be forced to return to Poland if she's unable to claim income support as a result of your right to reside legislation. That claim was rejected for reasons set out in paragraphs 43 to 46. Can I ask the court to cast their eyes over 43 to 46, please? And it's really paragraph 46 which reads across, we say very straightforwardly, to the facts of the present case, but in this case, in Ms. Mirga's case, the fact that social assistance may cause her, the refusal of social assistance may cause her to leave the UK is nothing to the point when it came to the directive, precisely because of the careful calibration in the directive regarding the availability of social assistance to migrants. So that's the first point. The second point is begins on 1107. The ruling is on 1107, and it is the rejection of an argument that was raised in that case, that the refusal of social security claims had not involved a sufficient consideration of the individual circumstances of the cases. And I should have showed you paragraph 58, which shows what the argument was, in fact. Mr. Drabble second argument: no consideration given to the proportionality of refusing each of the claimant's social assistance, bearing in mind all the circumstances of their respective cases. Failure to consider the burden which it would place on the system if they were to be afforded the social assistance which they sought. So it's an individual consideration argument, and Lord Neuberger refers to Alimanovic in paragraph 67 and to Dano and to Bry, and paragraph 68 he says it seems unrealistic to require an individual examination of each particular case. Cite some authority that you have in the bundle. Where a national of another member state, 69, is not a worker, self-employed or a student, has no or very limited means of support and no medical insurance, it would severely undermine the whole thrust and purpose of the directive if proportionality could be invoked to entitle that person to have the right of residence and social assistance in another member state, save perhaps in extreme circumstances, and I do acknowledge that qualification, would also place a substantial...
What does he mean by save in extreme circumstances here?
Well,
I mean, I know you're going to come to CG, which perhaps is the elaboration of that. I mean, this is the general principle. He's identified the existence of some form of limited derogation.
so what my submission is he explains that in paragraph 70.
Yeah.
Just finishing 69, it would also place a substantial burden on a host member state if it had to carry out a proportionality exercise in every case where the right of residence or indeed the right against discrimination was invoked. Now, paragraph 70, even if there is a category of exceptional cases where proportionality could come into play, I do not consider that either of the claimants could possibly satisfy it. I'd like to ask you to cast your eyes over the rest of paragraph 70. So you could have exceptional circumstances where the claimant was genuinely only going to be in need for a very short period of time, for example, and had been in the UK for a lengthy period, where there was a serious argument about proportionality of refusing benefit to them in that case. But not the case for Ms. Mirga and Mr. Samit, who had no significant means of support, had not worked for sustained periods in this country, and the whole point of the appeals was to enable them to receive social assistance when the self-sufficiency test was designed was designed to assist applicants who'd be very unlikely to need social assistance. And then 71, and summarising the effect of the line of cases that I've taken you to and which were considered in Mirga and Samit, whatever sympathy one might naturally feel for these claimants, their respective applications for income support and housing assistance represent precisely what was said by the Grand Chamber in Dano, supported by Alimanovic, to be the aim of the 2004 directive to stop, namely economically inactive union citizens using the host member state's welfare system to fund their means of subsistence. So in the line of cases on welfare benefits, the position was very clear. I mean, this is early 2016, but it continued to be clear with no hint of any departure from Dano, Alimanovic, Mirga, that there was to be no right to social assistance for migrants who were not residing in accordance with the directive and able to claim equal treatment pursuant to the specific provision, Article 24 of the directive. And our submission is that position was intended to be carried through into the withdrawal agreement, and I'll show you the provisions of the agreement in a moment. The final case that I wanted to go to by way of scene setting, as it were, is the HC case in the Supreme Court, which is in Bundle 2, tab 47. And could I ask you to refresh your memories as to the essential facts of the case in the head note between F and H on 1237 and going down to letter B on, in fact letter C on 1238. So this is a case about the so-called Zambrano right. We'll see in a moment what exactly that was, and it's a case which raised some relevant points, we say, in relation to safety net support and to the extent of the rights of EU citizens to claim benefits. There are 3 points that I wanted to get from it. On 1246, the first point in the judgment of Lord Carnworth, with whom 3 other members of the court agreed. 1246. You have his repetition of the Zambrano principle, the principle for Zambrano from Zambrano. And again, could I just ask you to cast your eyes over the quotation from Zambrano in paragraph 8 of Lord Carnworth's judgment. First point then that I want to make is paragraph 9 of Lord Carnworth. It is clear that the reasoning of the court turns specifically and solely on the risk of being obliged to leave the territory of the Union. There was no issue as to the nature of financial support, if any required, nor as to the extent of any right to benefits otherwise available to nationals. But what I take from it is that the citizen's right, the essence of the citizen's right being upheld in Zambrano, is not a right to live in a country to which you have moved. It is a right to live somewhere in the territory of the European Union. So the Zambrano principle was only triggered if it seemed that an EU citizen was likely to have to leave the territory of the EU altogether. And the reason why that might have happened in the Zambrano situation is you have a British citizen child with a third country national carer, and if the third country national carer can't live in the UK, they can't live anywhere else in the EU very often, and so the British citizen may have to leave the EU altogether. That's the Zambrano reasoning. But in terms of what giving effect to the right of citizenship means, it's you need to be able to live somewhere in the territory of the EU. That's the first point. The second point, also Lord Carnworth, is on page 1252.
Can I just ask you,
Yes.
it's reference to leaving the territory of the Union, which refers back to paragraph 44. Are you elevating that into a general principle, or is that just a statement on the facts of the case? It refers to those children. I mean, is this really just he's just describing the facts, or is it a more general principle?
Well, the Zambrano principle was, it was formulated first of all in Zambrano, but then applied in many, many other cases thereafter. The point that I take from this is in identifying the essence of the citizen's right. It's not the right to live in the UK. It's the right not.
In paragraph 45 of the quote you asked us to look at, refusing a third country national of whom his minor children are EU citizens are dependent a right of residence in the member state of residence. That doesn't seem to me to say. So where do we find that as long as you can lodge somewhere in the EU,
Yes.
you're all right? So well, how do you jump from paragraph 45 to your assertion? Where do I find that in the judgment?
So that's the point, that if the carer is a third country national who won't have in almost all cases won't have a right to live anywhere else in the EU apart from the UK, if they can't live in the UK, they will have to leave the EU altogether.
But therefore, to remain cared for by that person, the Union citizen also has to move outside.
That's right.
The EU. But that's the facts of the case.
Well, that's the.
I think we're just asking: is that a general principle, or is that just what happened on the facts?
Well, it is a general principle that the essence of the right of citizenship in this particular context is to be able to live within the EU. So if
and move in the EU to reside in a member state,
and to if there is somewhere else in the EU where you can live, then that's fine. But what can't happen is that the British citizen EU national is forced. British national EU citizen is forced to leave the EU altogether because his carer has nowhere else to go in the EU other than the UK.
If it's any assistance, that is accepted by us as being the essence of the Zambrano right. I hate to see my learned friend struggle when I think the point isn't in dispute between us.
it was very noble of you, Mr. Dano.
I've got the steer. You want to get on with it. So I thought I might help to cut things short.
So the second point then, if I can go on to that in paragraph 28, was a ruling on whether the charter could be relied upon by HC, the Zambrano carer. And it's the implementation of EU law test in Article 51. And Lord Carnworth says in paragraph 28, then, letter C, once it is determined that EU law does not require more for the children of a Zambrano carer than practical support sufficient to avoid their being obliged to leave the Union, that also sets the limits of what is involved in its implementation. Although it's open to the state to provide more generous support, gold plating as it's sometimes called, that is the exercise of a choice under national law, not EU law. So the point that's being made here is that, as we'll see in more detail in a moment, HC, the claimant, had subsistence support. She was getting support under Section 17 of the Children Act. There was no danger of her being required to leave the UK and therefore the EU. And Lord Carnworth says, well, therefore, not giving her benefits or deciding whether or not to give her benefits as well is not an implementation of EU law, because that would be extra. That would go beyond what the Zambrano right requires. So gold plating is not an implementation of EU law for charter purposes.
Yeah. I doubt that's in dispute either. But we'll find out.
It's not in dispute until we get to CG.
Any of this is in dispute, is it?
And
in terms of the judgment that you're appealing against, I don't think we read the UT as saying that it's inevitably the case that AT was entitled to universal credit. They were entitled to some level of benefit, which was not an issue in that case. So not certain if the issue of gold plating arises or not.
Well, I show you this partly because I want to help the court to understand what a significant departure from the previous case law CG was. Because one of the things that CG does is to say that the gold plating in that case did trigger the application of the Charter. So giving a right of residence under national law, which was not required by EU law, did trigger the implementation of the Charter. Did trigger the application of the Charter as an implementation of EU law.
If you're right that CG is both baffling and perplexing, what does that mean for us?
Well,
we may be baffled and perplexed, but aren't we bound by it?
Well, I will say not for various reasons. One of which is that, as a matter of interpretation of the withdrawal agreement, the UK should not be construed as having agreed to a wholly unorthodox and radical change to EU law, which happened after the end of the transitional period.
But aren't you skewered by 24 hours in the case of CG? It got the reference off a day before the transitional period ended, and under Article 89, aren't we bound by it?
Well,
Of course we are. I don't think that's in dispute either, is it?
no,
You're trying to say it doesn't apply in this case.
I'll be saying it doesn't apply in this case, and one of the reasons why you should find it doesn't apply in this case is that you'll be applying a wholly unorthodox and radical shift to the EU law.
But
let's assume
that means
that's
you're
correct.
asking us to go behind it.
Let's assume you're correct. What's the effect of Article 89 of the withdrawal agreement, which binds us to references made before the end of the transitional period?
Well, and you will have to decide, and I will be inviting you to decide that CG can't be read across to
that's
the
different.
different
You can say it doesn't
provisions of the
apply.
withdrawal agreement.
Yeah.
And I will say that it is of some relevance to that when you are construing the withdrawal agreement,
Right.
and you're looking at the background and the context and what EU law was when it was drafted and agreed to.
Yeah.
That you should take into account the well-established position in cases like HC that gold plating is not does not trigger the Charter.
So what's the gold plating in this case?
So the gold plating, as I will go on to explain, is the right of residence which AT was afforded under the domestic settlement scheme, which was a right that she was not required by the withdrawal agreement to be afforded. I'll show you recent authority as to the settlement scheme being more generous than was required by the withdrawal agreement.
Mr. Cobble, when you come to that, or whenever is convenient, perhaps you can also address why it particularly matters that this is a right that comes under the Charter, because if what the CJEU said in CG was right, this is a minimum level of support, you would have derived that under Article 3 of the Human Rights Act and what is sometimes called the common law duty of humanity. And this isn't a right to universal credit for everyone. This is just to ensure that you don't have destitution.
Well, my Lord, there wasn't in this case a claim under the Human Rights Act, and the Upper Tribunal was not deciding a case under the Human Rights Act. You are quite right to say that what the First-tier Tribunal and the Upper Tribunal in turn, in substance, seem to have done is to find that there was inhuman and degrading treatment contrary to the Charter, but also with the contrary to the Human Rights Act. But that simply wasn't the claim which was being brought. And there may well be arguments as to how the Human Rights Act would be given effect in the context of this legislation. That isn't an issue that I've seen canvassed in the papers for this case, although I haven't been involved for as long as others have.
I mean, I suppose one of the things we've been trying to get our heads around is the provisions of the Charter which were relied upon in this case, 1, 7 and 24, all have parallels either under the ECHR or in international law. And it's not as if they have suddenly sprung out of nowhere with the concept of dignity. It riddles the United Nations Convention on the Rights of the Child, for example. It's in the preamble to the UN Charter, into the 1948 Declaration, all of which is referred to in the explanations. So they're not entirely novel rights which are being grappled with.
No, and what I'll be accepting when we come to the Upper Tribunal's reasoning and to Article 4.3 of the Withdrawal Agreement, what I'll be accepting is that at least Articles 1, 4 and 7 of the Charter, so that's dignity, inhuman and degrading treatment and private and family life, were in any event general principles of EU law, whether we say they didn't come in via the Charter in this case, but they were general principles of EU law.
And domestic law.
I'm sorry?
And domestic law to the extent that they mirror rights in the Human Rights Act.
Human Rights Act. So, the final point, the third and final point that I take out of 8C, which is relevant to grounds 2 in particular, is the treatment of Section 17 of the Children Act support in the case of the Zambrano carer. That is one of the predominantly local authority administered schemes of safety net support, I know, which was being provided to HC. The third point that I take then is the treatment of that source of support in HC, and I wanted to show you paragraph 36, first of all, of Lord Carnworth. And at letter B on page 1255, he says that on the view I've taken of the allocation of responsibility for that support, and that support is the support which is necessary to prevent the citizen having to leave the EU. On the view I've taken of responsibility for that support as between central and local government is an issue of national rather than EU law. That does nothing to diminish the importance of the duty. In 37, he expresses some doubt as to the appropriateness of judicial review as a means of regulating provision of Section 17 support. But he endorses what Lady Hale says in her judgment to the final sentence of 37, and you then go to 46, where Lady Hale sets out what local authorities will be required or are required to bear in mind in carrying out their duties under section 17. And you will have read this, I'm sure, as a sidelined passage. And going over to 47, she says, the above, of course, is premised on the dismissal of this appeal. Zambrano and the later cases say nothing about entitlement to benefits, but they do recognise that the children are dependent upon their parents, not just for care, but also for financial support, at least if derived from the parents' ability to work. The situation of Zambrano carers and their children does not fall within European legislation on access to social security and other welfare benefits. All that Zambrano requires is that the children are not effectively deprived of their rights as European citizens by the situation in which they find themselves. Section 17 support, at least if it is determined giving due weight to the factors suggested in paragraph 46, should be sufficient to ensure they are not effectively deprived of their rights as British and European citizens.
One of the problems with section 17, isn't it, is there's a duty to assess, but there's no duty to then carry the assessment into effect. And we all know from the passage you've just taken us to that whilst technically judicial review would then be available, it's by no means satisfactory. So, you know, what you've got are impoverished local authorities with very, very patchy response to their Section 17 obligations. Usually a Section 17 payment is a modest payment to cover nappies. And they have no duty to implement their assessment. You're saying that that's a sufficient safety net and that the Upper Tribunal was wrong in not regarding that as the answer.
Well, we submit, my lady, that is not a complete statement of the duties of a local authority under Section 17 in a case where Article 1 dignity or Article 3 inhuman and degrading treatment, so forth, might be engaged, and the point that Lady Hale is making in setting out the duties of local authorities in that case in paragraph 46, and then saying that if those duties are borne in mind, the Section 17 support will be sufficient, should be sufficient, to ensure that EU citizens are not forced into the situation of having to leave the UK, the EU altogether. And we say there is a...
This is what you're relying on for your ground 2 then, your Section 17, this passage?
That's part of what we rely upon. And we rely as a freestanding and we say self-evidently correct principle of law that a local authority will have a duty to provide support.
No, they have a duty to assess under Section 17.
But in a case where there is a danger of breach of a fundamental right, like Article 3 inhuman and degrading treatment, their Children Act duties will go further than simply assessing, and they will include the provision of support which is sufficient to avoid a breach of convention rights. So
is this an argument about whether it's the central government or local government that picks up the bill?
So the points are, first of all, that it is a matter for each member state to decide which limb of government should be responsible for which type of support. There are not simply financial issues, but there are real questions of expertise and boots on the ground, as it were, in terms of why it makes sense for local authorities to be assessing people who are in the area, who have the day-to-day contact with the individuals why it makes good sense for them to be assessing support needs rather than to erect a separate and really quite radically different structure of social security entitlement to take account of this kind of individualised assessment.
Would it follow from that that if it's the duty on the state as a whole, whether central or local, to provide the baseline support, that central government would have a discrete incremental duty to fund local authorities to ensure that the duty could be complied with? Because otherwise, there's no point in allocating it to local authorities, is there? Does it follow from your analysis that the state can... the state would be in breach of its duty. We're assuming here that there's a duty to provide that baseline support. So that's our hypothesis. Then the question is, who does it? It can be done by the state, centrally or locally. If it's done locally, but they're not given sufficient funding so that it isn't then carried out and the money doesn't get to the individual, is that a breach by central government?
Well, Lord, I don't accept the factual premise that there could be a situation where a local authority did not have sufficient funding to perform its statutory duties. And this actually was a claim brought by Liverpool City Council a few years ago about one of its statutory duties in relation to the deprivation of liberty safeguards, and they said we aren't getting sufficient funding from government to enable us to perform these duties. Answer from Mr. Justice Garnham is you do have sufficient funding to perform your duties, and it's difficult to envisage any circumstances in which you wouldn't, because in fact what you do is you spend some money on performing duties and a lot of money on doing things which aren't duties. So you will always have, or local authorities will always have sufficient funding to perform their statutory duties. Lord, I fully take on board the...
I mean, we're not going to get into politics here, but in a sense, there may be an issue behind the scenes as between central and local government here, which is not for us. I mean, I can see that it is the obligation of the state to comply. Thereafter, how the state complies is a matter for the state, and it doesn't arise in this case as to whether or not alleged non-compliance by a local authority amounts to non-compliance by the state. But there is a point in this analysis that, particularly under the heading of Section 17, and as my lady says, it isn't at the moment a particularly adequate tool for addressing this, unless, as you suggested, it is transmogrified into something far more powerful than it is at the moment.
Well, it is at the moment a far more powerful duty in certain extreme cases, be it Section 17 or the other local authority administered safety nets. When read with the Human Rights Act, and as one should do, as Lady Hale did, one proceeds on the basis that local authorities will fulfil their duties. It is already a powerful duty in the extreme cases that we are concerned with here. So that completes my description of where we were at the point that the withdrawal agreement was negotiated and then entered into. That was entered into on the 24th of January 2020. We have set out some of the key provisions of the agreement, referred to the key provisions in paragraph 28 onwards of our skeleton argument. You've seen them also in the judgment of the Upper Tribunal. There are certain provisions, as you know, which we'll need to come back to in more detail. But I wasn't proposing to show you much more at this stage than to remind you of paragraphs 28 to 31 in particular of our skeleton argument. I think the only thing I perhaps should show you is Article 127, which I won't be coming back to, on page 230 of the Authorities Bundle, tab 13 of Volume 1.
Sorry, did you say tab 13?
I think I did say tab 13, I think that was right.
238.
Yes, tab 13 at 230.
Thank you.
And 127.1 is the provision for, unless otherwise provided, union law shall be applicable in the UK during the transition period. During the transition period, EU law applies unless specifically excluded. After the transition period, EU law must be specifically included, otherwise it doesn't apply. So big change at the end of the transition period. And one of the specific exclusions during the transition period is in 1B.
That last sentence, which I noticed the tribunal picked up and put it in more or less the same terms as you did in relation to 127, it's really to be inferred from 127 rather than express.
Yes, it's 127 read with Article 4, or certain bits of Article 4, which we'll come to, and Article 2. Perhaps we'll look at Article 2 in a moment.
But it's that add-on, because it doesn't, I mean, and you put it in terms which I saw the tribunal put it in, after the transitional period, EU law must be specifically included within the WA to be operative in the United Kingdom, and it then flows through Article 4 and then through Section 7 into domestic law.
Yes, I'm reminded that one of the recitals to the withdrawal agreement. So on page 206 of the bundle, the recalling recital. Pursuant to Article 50, and subject to the arrangements laid down in this agreement, the law of the Union in its entirety ceases to apply to the UK from the date of entry into force of this agreement. And then the transition period, Article 127, is by way of exception to that.
But then at the end of the transition period, it's only those provisions of the WA which apply as international law, albeit derived from EU law. It's really what happens at the end of the transitional period. The WA continues to apply, but only with those provisions contained in the WA.
Only with those provisions of EU law which are specifically...
Yeah.
Yes.
And now take effect as international law.
I'm only hesitating because I don't want to mangle what Article 4.3 says.
No, understood.
But that's...
I was just interested because that seems to be its inference rather than express in the WA. Seems to be logic, but yeah. Okay, thank you.
So I think I was back on 127. I was on 230. Article 127 on 230. I was going to show you 127.1b, which is the exclusion of various provisions, including specific provisions of the Charter of Fundamental Rights, which are two of the political rights in relation to voting and standing for the European Parliament. But we say a specific effort to carve out parts of the Charter which don't apply in the transition period. No similar provision for post-transition period, but on the Upper Tribunal's analysis, in principle, the whole of the Charter will come back in this context, with no anchoring as to which bits are relevant and which not. Very quickly then, Article 13 on page 213. 213. Union citizens and UK nationals shall have the right to reside in the host state under the limitations and conditions as set out in Articles 21, 45 and 49 of the treaty and various provisions of the Citizenship Directive, so at least echoing the structure of Article 21, but will, as I'll come on to submit, conferring a very different right to what Article 21 confers. And Article 23, finally, at the moment on 219, equal treatment. There is a provision in more or less identical terms, and I appreciate some issue about this that may come up in future in these proceedings, but what on their face look like the terms of Article 24 of the directive. You've got to be residing on the basis of the agreement, 23.1, and then a derogation in 23.2.
If you reside on the basis of this agreement, and through Article 13 it takes you into Article 21 rights, is that what meant by residing on the basis of this agreement?
Residing on the basis of the agreement takes you back in particular to 13.1, which will be, and I will be coming on to this in a bit more detail later on, but it will be the right of the UK citizen to reside in a single host state where he or she was living at the end of the transition period, and the right of an EU citizen to live in the UK.
Via Article 21 and the CRD, or
no?
13 cross-refers, it brings in by cross-reference.
Well, I will come on to this. We say it's not. I mean, it's not the Article 21 right. It's completely different from the Article 21 right. It's not a right to move and reside freely amongst the member states.
Well, it can't be. Well, it can't be.
It can't be.
It's a modified. It's as near as damn it, if you like. The 21 right is consistent with the UK having left. So if a French person comes to live in the UK during the transition period, do they then give them rights to move anywhere in the EU? Or, I mean, it is a more limited right.
It is a very much more limited right. It's not near as damn it. It's very far away. Okay. We would say from what Article 21 provided until the end of the transition.
My lord, forgive me for jumping up. I'm sure my learned friend would agree that there is an issue about the operation of Article 13 that has been reserved by the tribunal. It's one of the issues upon which they haven't decided, and we're getting into the type of substantive argument we would raise in relation to that issue. Our case, so that we're clear, is that Article 21 has a different field of application. It applies to every circumstance where you have a right of residence reserved by the treaty, and a differently configured derogation, and that makes it very different to Article 24. But I don't think that that's an issue we need to determine for the purposes of today's hearing, because that issue, along with wider issues about discrimination, including discrimination under the Human Rights Act, being parked if necessary for another day.
Does that, I mean, maybe we don't need to get into this, and correct me if I'm wrong, does that then affect the nature and classification of the rights that AT was exercising in the UK at the relevant time? Whether they were Article 21 rights, or you say they weren't. You say they were gold-plated rights, but I'm not certain that's necessarily accepted.
Well, look, can I come on to it? I'm coming to it very soon.
Okay.
But I will address your question. The next point in the narrative is the EUSS scheme, which, as I've submitted, and I'll just give you a reference to authority, the recent IMA case, Volume 3, Tab 64, Paragraph 14, is more favourable than was required by the withdrawal agreement, in particular because it confers rights on people who were merely present in the UK without at the time exercising any of the residence rights conferred by the withdrawal agreement. So just referring back to Article 13, this requires certain residence rights to be afforded. The EUSS settlement scheme afforded rights to people who weren't residing on the basis of any of the in shorthand directive rights referred to in Article 13. It's more favourable in other ways as well, but I don't think I need to go into those. The CG case, then, you've seen the very detailed exposition of the CG case in the Upper Tribunal judgment at 45 to 56. Can I just make a couple of points from the CG case, please? And have that in Volume 3, Tab 61. Sorry, have I got the wrong tab?
Yeah, that's right.
Sorry,
61.
I got the wrong tab. 59. Sorry, it's a different language version. 59. So timing-wise, referred just before the end of the transition period, handed down after the transition period, concerned with EU law as it stood during the transition period. And not as it stands, or not as it applies in the UK following the end of the transition period, and that's the issue. Whether the end of transition period reasoning can be read across to the post-transition period withdrawal agreement context. The main issue raised by the appeal tribunal, and I'm on paragraph 37 of the court's judgment on, I believe, 1689 of the bundle.
The Upper Tribunal judgment.
I'm sorry. I'm in CG, and the issue raised by the Northern Ireland Appeal Tribunal for the Court of Justice. Paragraph 37 at letter F to G, the claimant maintained, in accordance with the judgment in Trojani, that she is entitled to rely directly on that provision, Article 18 of the treaty, in order to be granted social assistance on account of the fact that she has a right of residence under national law, that's under the settlement scheme, even if she does not satisfy the conditions for obtaining a right of residence under EU law. So that's the settlement scheme giving her a right which EU law, the directive in particular, didn't give her. And then, if I could ask you to turn to paragraph 72, please, on 1695. The question as reformulated, or the issue as reformulated by the Court of Justice, whether Article 24 of the directive precludes legislation of a host member state excluding from social assistance economically inactive union citizens who do not have sufficient resources to whom that state has granted on the basis of national law a temporary right of residence where those benefits are guaranteed to nationals of the member state. And the first thing that the court does in answering that question is to uphold the Dano line of reasoning, paragraph 75 onwards, and paragraph 78 in particular, upholding Dano, a member state does have the possibility, pursuant to the directive, of refusing to grant social benefits to economically inactive union citizens who exercise their right to free movement and who don't have sufficient resources to claim a right of residence. And that was CG's situation, see paragraph 80, not called into question, see paragraph 81, by the fact that she had a more generous right of residence under national law than was required by EU law. And then paragraph 82, the court explains that the settlement scheme more generous right falls into the scenario referred to in Article 37, to the effect that the directive does not preclude the law of the member states from establishing more favourable rules than those laid down by the provisions of that directive. That's gold plating. So then the second point, the court goes on to decide, even though it hadn't been a question referred by the appeal tribunal, goes on to decide that the charter is applicable in the circumstances of CG's claim. And we say, contrary to the approach in Dano, well, you'll recall that the setting of conditions for special non-contributory benefits was not implementing EU law for the purposes of the Charter, but a different conclusion reached. And as I'm sure you have seen, it's in particular paragraphs 87 and 88, where the Court of Justice decides that the more favourable rules under the settlement scheme, see 87 at letter C, cannot be regarded as an implementation of the directive, but in so doing, those authorities, by contrast, recognise the right of a national of a member state to reside freely on its territory conferred on EU citizens by Article 21 of the treaty, without relying on the conditions and limitations laid down by the directive. 88, it follows that where they grant the right in circumstances such as those in the main proceedings, the authorities of the host state implement the provisions of the Treaty on Union Citizenship, and they are accordingly obliged to comply with the provisions of the Charter. And if you follow back the reference to paragraph 62, and indeed 63 earlier in the judgment, the provisions on union citizenship referred to are Article 21 and Article 20, subparagraph 2, subparagraph A.
Just in terms of constitutional hierarchies, the treaty must take precedence over a directive. So I can understand when the treaty in Article 21 says implementation, or you elaborate through a directive. The directive can't take away a right in the treaty, it can elaborate upon it. So the right in 21, this seems to suggest, it freestands separately from the derivative directive right.
Well, that's what seems to be being said. It's an implementation of the treaty right without the conditions and limitations in the directive.
Yeah.
Look, it's not entirely that simple because as we've seen in relation to the discrimination right, the court has decided that the directive is the lex specialis, and you can't fall back on a broader treaty right. But that's what seems to be being said. There's a separation between the treaty right and the conditions and limitations which are stated in Article 21 as defining the treaty right.
Yeah. This wasn't a grand chamber, but it seems to have been 15 judges. Looking at the front page, it seemed to have most of the presidents of the chambers.
I'm told it was a grand chamber by
It was a
junior
GC.
who was.
It looks like a GC.
And as my lord can see, it was convened at very great speed.
Yes.
Yeah.
And I'll come
But
back.
that's not insignificant. I mean, if you'd had a three-person court after a grand chamber in Dano, one might have said, these things happen, but this was quite deliberate.
Well, it's
Setting a trap for you here.
I wouldn't go so far as to say it was quite deliberate, because of course there's no acknowledgement of the radical shift from the Dano ruling that you're not implementing the charter.
But you know what the court's like. They don't tend to herald their radical shifts, do they? They slip them in.
Well, my lord, I can't accept that it was deliberate without any explanation or acknowledgement in circumstances where Dano has been upheld earlier in the.
But they're upholding Dano, or they're glossing Dano. I mean, they're not saying that Dano was wrongly decided. They work their way through Dano and Ziolkowski, all of which really say yes, benefit tourism is out. But then there's this but. There's a bare minimum which they're inserting, a floor below which you can't fall.
But it's difficult to see why the same argument couldn't have been run in Dano if it was a good argument.
That's how the common law works.
The ruling on the charter in Dano was quite simple.
Yeah.
You're simply not implementing EU law when you decide on conditions of special non-contributory benefits, and that wasn't because of any looking at a particular residence right rather than another residence right. Simply, this is a matter for national law.
Did the Advocate General set this up in any way?
Well, set up is probably an exaggeration.
Herald? Analyse?
No, not.
Paragraph 81 might be persistence at 1671.
As I'm sure my Lord Justice Dingemans will recall, the case actually turned upon the binding effect of previous jurisprudence in Troiani. In fact, the main thing that's happening in this case is that the Troiani case is being overturned. And what the CJU isn't saying, because it never does, is that it's departing from its previous case law. That issue is expressly grappled with at length in the Advocate General's opinion. And effectively, the proviso in this case is a proviso to taking away with the one hand and why Troyani ruling and giving with another. I'm sure my learned friend's going to explain that.
Well, there's certainly some creative thinking on the other side as to what the explanation for this might have been. I'll leave Mr. Delano to explain it for himself. Can I then? I'll need to come back to CG for the third aspect of the case, which is the how you apply the charter rights.
Yeah.
When I come to my later grounds, but can I then take you to the Upper Tribunal ruling, beginning at paragraph 96, please.
Sorry, paragraph
96, on page 131 of the full bundle, you may have it. So what the Upper Tribunal decided in substance was that the provisions of the withdrawal agreement, which it goes on to analyse in this section of its judgment, required that the reasoning in CG should be applied to cases which arose after the end of the transition period and not simply, as in CG, during the transition period. Now, there are three stages to the Upper Tribunal's reasoning, corresponding to the headings above paragraph 96, 103 and 106. And if you could have open Article 4.3 of the withdrawal agreement, please. It's on page 209 of volume 1. It's in the Upper Tribunal's judgment as well, but perhaps it's easiest to see on 209 of volume 1. The three stages of reasoning, the three headings, correspond to the three clauses within Article 4.3. Three clauses, as I'll break it down. First of all, the provisions of this agreement referring to union law or to concepts or provisions thereof. That's number one. Number two, shall be interpreted and applied. And number three, in accordance with the methods and general principles of union law. So, stage one, which is 96 to 102, the Upper Tribunal decides that Article 13 of the withdrawal agreement is incorporating part, and a sufficient part, of Article 21 of the treaty. And you'll see the conclusion at the end of 102, the last 4 or 5 lines of 102 in the Upper Tribunal. Now, we submit that the Upper Tribunal's analysis was wrong, and that the resident right conferred by Article 13 of the withdrawal agreement does not incorporate, to any extent, the Article 21 right of citizens to move and reside freely in the member states. And to the extent that it incorporates it in a modified and reduced form, it is such a modified and reduced form that we say it is scarcely meaningful to describe it as the Article 21 right at all. We say that the residence right conferred by Article 13 bears no resemblance to Article 21. We've explained this in paragraph 52 of our skeleton. And let me summarise why. Article 21 is a right of EU citizens. The UK no longer recognises EU citizenship, no longer after the end of the transition period, no longer recognises EU citizenship. So the right conferred by Article 13 of the Withdrawal Agreement, so far as EU nationals are concerned, is no longer a right flowing from EU citizenship. And of course, as far as UK nationals are concerned, they are no longer EU citizens, so it can't flow from EU citizenship.
AT remains an EU citizen, even if her English or Welsh or Scottish equivalent doesn't.
They remain an EU citizen, but the reason why they have the right in Article 13 is doesn't flow from their citizenship. It flows from the negotiated terms of the withdrawal agreement, notwithstanding that the UK no longer recognises EU citizenship.
Article 13 has two categories of person. It has an EU citizen and a UK national. So obviously UK nationals are not treated as UK citizens. So they shall have the right to reside in the host state. That's either it's somewhere in Europe or in the UK, under the limitations and conditions set out in 21, 45 or 49 and CDR.
Yes. And well, my point is it's a simple point at this stage of the analysis. So far as EU citizens are concerned, this is not a right. I mean, certainly there is a category of persons described as union citizens, but this is not a right which is a consequence of their treaty, of their TFEU rights as citizens.
No, it's an international law obligation.
It's an international...
But that cross-refers to another provision, which now takes effect as international law, not EU law, namely Article 21 and the CDR.
Yes, it does cross-refer to Article 21, but we are I'm making submissions.
Is that not included by reference, incorporated into the WA by reference? So it becomes international. It's part of the WA.
So we say it is not. The Article 21 right is not incorporated by reference. The Article 21 TFEU right is a right of citizens. The UK no longer recognises citizens. This is not a right any longer to move and reside freely in the member states, but a right for the UK national to reside in a single EU state and for an EU citizen to reside in the UK with no correlative right to move to any other state. Of course, the EU citizen doesn't need it because they get it from the treaty, but the UK national doesn't have it.
Just as a matter of legislative drafting, why is it not incorporated by reference? It doesn't have to set out Union citizens and UK nationals shall have the right to reside and then recite everything that is contained in Article 21 or the CRD. So does it have to be writ large to be incorporated into the WA?
Well, Lord, it's partly a matter of wording of Article 13.1, which of course doesn't refer to the Article 21 right at all. It refers to the conditions and limitations on the Article 21 right.
But it refers to the right to reside. Where does that come from then?
And then it's a matter of content of what right is being conferred, and it is not the Article 21 right to move and reside freely amongst the member states. It is a right to reside in the UK on the one hand and in a host state on the other hand. So it's both wording and substance.
So the limitations apply but not the right?
Well, that's what's referred to on the face of
I understand. I'm just trying to...
13.1.
So,
and I'm sorry.
No. You go on. Sorry.
The limitations and conditions then are set out, and there are references to treaty provisions, but also reference to the directive, which confers rights of residents. And there's a contrast, if I could draw contrast with Article 24 of the Withdrawal Agreement on Rights of Workers, 219. Subject to the limitations set out in Article 45, 3 and 4 TFEU, workers in the host state and frontier workers in the state or states of work shall enjoy the rights guaranteed by Article 45 TFEU and the rights granted by regulation, etc. So where there is an intention to confer a treaty right in the withdrawal agreement, there's a very simple way of doing it.
What do the word conditions mean? I'm struck by the fact it also refers to the right. It uses the definite article as opposed to a right. I mean, what is the right? It's referring to some corpus of law, isn't it? You simply say it's to national law. The law. In the case of France or Germany, what would that be? Not French law or German law. They have a right under Article 21. So what would be the equivalent under... I mean, this is meant to be symmetrical. It's meant to be the same right in France and Germany as in the UK. What would the be?
Well, the right to reside I wouldn't draw any distinction between the right to reside and a right to reside.
Well, then delete the words under the limitations and shall have the right to reside in the host state under the conditions as set out in Article 21. Wouldn't that then trigger the right? If you meet the conditions, you get the right.
Well, the limitations and conditions is a well-worn is phraseology that's drawn from Article 21 and is limitations and conditions in the treaty itself and in the directive. And that's well-worn terminology.
So it's not the condition precedent for exercise of the right.
Well, the conditions and limitations. So, I mean, take the directive rights. There are conditions precedent in the directive. So, for the right of self-sufficient persons, you need to be self-sufficient. For example, for job seekers, you've got a certain length of time to exercise the right. There are conditions. Of course. So I fully accept the limitations and conditions is a direct reference to the language of Article 21. But of course, this case isn't about the limitations and conditions because it's accepted that AT didn't satisfy the in particular directive limitations and conditions. So there's no question of interpreting them in accordance with union law. What this case is about is whether there is an Article 21 right, which is brought in earlier in the article, and we say simply not. It's so different from the Article 21 right as to.
And just so I'm absolutely clear, if it's not Article 21, where does the right come from? Assuming this is a right for both UK citizens and Union citizens.
The right comes from this provision. Shall have a right to reside pursuant to Article 13.1. Well, this is perhaps one thing it can be lost sight of. This is a new international agreement that itself confers rights which people wouldn't otherwise have.
It doesn't say, okay, well, I understand the point.
It doesn't say two sentences. Union citizens and UK nationals shall have a right to reside, full stop. That right will be subject to the conditions and limitations contained in. It's a single sentence.
I understand the point. I mean, we just have to grapple with the language.
Well, I would submit it makes no difference whether it's one sentence or two. There's a right being conferred here. It's nothing like the Article 21 right, and it's subject to the same limitations.
Well, I mean, I think we've got your submission on this, and we'll have to grapple with where the word under fits in, for example.
So the second stage of the Upper Tribunal's reasoning is in paragraphs 103 to 105.
Sorry, just before we move on, we did, sorry, just to complete that, recollect in this, I can't remember, someone's skeleton argument. My apologies, whoever wrote it, and I've forgotten momentarily where it was. Of course, we do have to look at Article 13 as a whole article, don't we? So we've got to look at number 2 and 3. So is your submission that the family members and the children have the right to reside as set out in Article 21, but their parents won't?
Well, I say that there. I mean, for stage one of the analysis, I say that the family members equally don't have an Article 21 right that bears any sufficient resemblance to the Article 21 right of citizens.
So we have to, nationals shall have the right to reside in the host state as set out in Article 21?
So the wording is different in Article 13.1. I'm not saying that the case turns on that, but I do say the case turns, or this part of the analysis turns on the substance of what's being conferred here.
Sorry, I interrupted you.
I should also say that there are rights of residence conferred. Or that the scope of the rights of residence conferred by Article 13 are more limited than the rights conferred by Article 21. So, for example, there's no Zambrano right within Article.
The tribunal accepted they were more limited, didn't they?
More limited because the withdrawal agreement, for example, doesn't permit UK nationals to assert a right of residence against the UK, which is the Zambrano right, the surrender sing right. So again, it's a different right being conferred. So stage 2 of the Upper Tribunal deals with the third clause of Article 4.3 in accordance with the methods and general principles of union law. And the conclusion, as you've seen, is that the charter comes in for the reasons set out in paragraph 105. In about the middle of the paragraph, the methods in accordance with which the provisions of the WA are to be interpreted and applied include those of the charter. Thus, Article 4.3, taken with Article 2, requires the parties to act compatibly with any charter or fundamental rights relevant to the situation. And our submission is that methods and general principles of EU law is not a gateway or a portal for the whole of the charter to be brought in circumstances where during the transitional period there was specific provision made for the charter to continue in the absence of certain rights. Now, we do accept, as I said earlier, that Articles 1, 4 and 7 of the Charter reflect general principles of EU law. So, for the purposes of this case, it may not matter much to the result, because we accept that in accordance with the methods and general principles of union law includes in accordance with the general principles, including human right to dignity, and so forth, what we are objecting to at this stage of the analysis is the bringing in of the whole of the Charter in this way.
So just help me with this. So in the provisions of this agreement referring to union law, and you're saying that the Upper Tribunal was wrong in incorporating the Charter. So just tell me how that fits in with the definition section of union law in Article 2, which includes the Charter.
So
just to explain to me how that
so,
works.
so our submission is it's methods and general principles of union law, which is, on the one hand, methods, so teleological interpretation, take account of the whole of EU law, different language versions, travaux préparatoires, all the usual methods, and general principles of union law. The Charter in its entirety is not a general principle of union law. The Charter contains some fundamental rights which are general principles. It also contains a whole lot of principles and a whole which aren't general principles of EU law, and a whole lot of social rights, political rights, which haven't been recognised as general principles of union law.
Is a method, does method include construing, let's assume for the sake of argument, to keep it nice and tidy, let's assume Article 21 applies in its entirety. I know, just assume that for the sake of argument. Is a method of interpreting Article 21 to ensure that it complies either as to its interpretation or application with the Charter? Is that a method?
We would submit not, and not the Charter in its entirety. That can't be what was meant in circumstances where, for example, you have the specific provision made in the transition period for the Charter to apply in a modified form, but no similar provision made for after the end of the transition period.
So if you're saying that the Charter is neither a method nor a general principle, why is it included in the definition of union law? What help does it give us?
Well, the Charter is part of union law as defined, and the Charter, as a part of union law, does contain some general principles of union law. For example, Article 1, Article 4, Article 7. But the Charter, and I don't think anyone has argued that the Charter, in its entirety, contains general principles of union law. We don't have the whole of it in the bundle, but I could take you through.
No, please don't.
No, but thank you. So, insofar as there are general principles of EU law contained in the Charter, then they will come in via that. But they aren't general. But they're general principles anyway, which the Charter happen to incorporate.
Okay, thank you.
Can I just check what you're objecting to in paragraph 105 of the judgment of the Upper Tribunal? So if you're up 4 lines from the bottom, Article 4.3 taken with Article 2 requires a party to act compatibly with any charter or fundamental rights. You say charter is too wide, but if they'd substituted for that the relevant bits of the Charter, in this case Articles 1, 4 and 7, you'd be happy with that, would you?
Yes.
So,
yes.
I mean, this is beginning to be a bit of an exercise in semantics.
Well, as I said at the start of
my lady already gave you some indication about time.
Yes. Well, I shall move on to what I believe will be the critical stage of the Upper Tribunal's analysis, which is the third stage, which is 106 onwards. Was the Secretary of State applying a provision of the withdrawal agreement referring to EU law when determining AT's application for universal credit? And we say that the Secretary of State was not applying Article 13 of the Withdrawal Agreement, or indeed in interpreting Article 13 of the Withdrawal Agreement, when deciding upon the universal credit application. We've summarised our argument on Article 47 of our skeleton argument. The independent monitoring authority, paragraph 34 of their skeleton, have given examples of what amounts to interpretation within Article 4.3, the Coman case, Bundle 2, tab 50, and what amounts to application within Article 4.3, the Rondon-Marin case, Bundle 2, tab 44. We say that neither of those is happening here, and neither case is analogous to our case. And one has to look then at how the Upper Tribunal reasoned that the Secretary of State was applying Article 13 of the Withdrawal Agreement. And what they say in relation to that, and really the key sentence in the whole of the judgment we submit, is the second sentence of 106. CG also establishes that SSWP was acting in the scope of CG's Article 21 right to reside when deciding her application for the social assistance necessary to make the right effective. By parity of reasoning, SSWP was applying AT's modified Article 21 right to reside, the right conferred by Articles 10 and 13, when determining AT's application for universal credit. So the reasoning is that Article 13 is being applied because the application for social assistance was necessary to make the right of residence effective. And my learned friend, in his skeleton argument, Mr. Delamere, takes up that reasoning and runs with it. Can I show you? So it's paragraph 39 of my learned friend's skeleton argument. And if you look at 39A, he quotes the words that I've just read to you, and he says, "This is a reflection of the fact that a right of residence specifically for EU nationals who exercise their free movement rights before the end of the transition period, and which is recognised by a state which was not safeguarded against circumstances breaching CFR rights, would not be an effective right, particularly so in relation to a denial of benefit required to survive above destitution, which is likely to drive a person from the UK, stripping them in practice of the very right of residence which is meant to be preserved." Now, no authority for that reasoning is cited by my learned friend, and nor by the Upper Tribunal, apart from CG itself. And the Upper Tribunal cites CG in paragraph 106 as something from which, by parity of reasoning, it is said to follow that the Secretary of State was applying within Article 4.3 of the Withdrawal Agreement. Now, we submit that CG was not the basis for the reasoning in CEG was nothing to do with making effective her right of residence, and that is not what the Court of Justice says. What the Court of Justice says is that the UK was implementing Article 21 for Charter purposes, not that it was necessary to grant, or may have been necessary to grant, the application for universal credit in order to make the domestic right of residence effective. That's simply not there. And there's no authority cited by the Upper Tribunal or by my learned friend for this reasoning, because not only is there no authority, but it is utterly contrary to what authority there is, like Mirga, where a similar argument was run, like Zambrano.
But you can't say Mirga. I mean, 69 and 70 contemplates exceptional circumstances where precisely this scenario does arise. So prima facie, you're absolutely right. Mirga says there is no right, you don't have a right if you're basically a benefits tourist in order to enable you to exercise the right. So far, 100% with you. But then, if there is an exception to that, it must mean that there is, in those exceptional circumstances, a duty on the state to grant such support as enables the right to be effective. Yes. That's the corollary of what they're saying, isn't it?
So that's the second point that I took out of Mirga. I'm relying on the first point
Understood.
that I took out of Mirga,
Yeah.
which is that it's simply not open to a claimant, to a migrant seeking social security benefits without a right of residence. It's simply not open to them to say, I'm going to have to leave the UK if I don't get
That's
this.
Dano.
And that is Dano, that is Alimanovic, and umpteen others. But that is the argument which you're being invited to accept
On the back of CG.
Well, on the back of CG, but there is certainly, and we can go back and look at the wording again of CG. It is the UK, which was it's paragraphs 87 and 88. The UK recognised the right of a national of a member state to reside freely under Article 21 without relying on conditions and limitations. And paragraph 88, it follows that the authorities of the host member state implement the provisions on citizenship when they grant such a right, and so must comply with the Charter.
I understand your point about Mr. de la Mare going further, but whether the Upper Tribunal went further. And this was a case where it wasn't a person who was destitute in this country but could easily travel to another member state and have the support of a family. This was a person who was destitute wherever she was going to be. And that's a distinction, because that might be the exceptional case that was contemplated in Mirga.
So the exceptional case in Mirga, that section of the judgment is the second argument pursued by Mr. Drabble, which was there needed to be a proportionality assessment. Answer there, they didn't say in the exceptional case where somebody is almost self-sufficient but not quite. But as I say, I'm relying on the first argument rejected by the Supreme Court, which is it is nothing to the point that you may have to go back to your host state, your home state, which is the state that's supposed to be providing your social assistance. Now, Mr. de la Mare, in the paragraph that I've read to you, 39A, isn't going further than the Upper Tribunal. 39B certainly does. 39A is simply, in my submission, spelling out what the Upper Tribunal clearly thought in paragraph 106, that there is some kind of effectiveness principle. The Article 21 right that it saw as being brought into Article 13 can only be effective with a grant of universal credit. Or that's why the Secretary of State was applying Article 21. Quite different from CG implementing Article 21 by granting a gold-plated, more favourable domestic right of residence. And the effectiveness point, I say, contrary to authority. I think I referred in my answer to Lord Justice Dingemans a moment ago to I referred obliquely to a principle of EU law which one sees in a whole line of cases starting in Trajani, that a person who requires social assistance will presumptively be taken care of by their host member state. Can I just give you a reference or two? I don't want you to turn it up, but it's Trajani, Bundle 2, tab 26, AG 70 at page 505, endorsed by the Supreme Court in a case called Patmal-Nietzsche, and you have the extract from Patmal-Nietzsche in HC, paragraph 59 on page 854 of the bundles. That's tab 35, page 854. So the Upper Tribunal has plainly, in my submission, brought forth some new reasoning that's not in CG itself nor anywhere else. Whether it's right or wrong, that's for you to decide. I say that it is wrong. And if it was right, then the Court of Justice in CG wouldn't have needed to rely on the Charter. Simply have said effectiveness necessary to make the Article 21 right effective. No need to depart from Dano. That would be it.
Is the answer to that in cases like Dano, they were saying it's not a matter of having an effective right, you simply don't have a right. You may be indigent and you can leave the country, no one's stopping you, but you don't have any right to exercise, so it's not a matter of making it effective. And then they rode back just a wee bit in CG and said, well, there may be a limit to that, where we've got to make the right effective, which is if you are serious in seeking to use the right or you have a right, it's got to at least be exercised in a dignified manner.
Well, if one thinks about Dano in the later context of CG, the claimants in Dano had a right to be in Germany just as much as CG did.
Are you sure about that?
Well, the claimants in CG had a residence permit, and there was no question of them being removed from Germany. There was no issue about it wasn't questioned or wasn't argued that their residence in Germany needed to be made effective by the grant of benefits. My lady's looking sceptical.
No, on.
I understand there has been argument on the precise nature of the right of residence in Dano in other cases.
In
Fritilla, Mr. Justice Swift at first instance.
That's what I was recollecting.
But we submit, so far as it matters, and it's some steps removed from my argument, but so far as it matters, there could have been an effectiveness point taken in Dano, or indeed in Alimanovic, where they did have a right under the directive. Perhaps that's the better analogy. They did have the job seekers' right under the directive. So
maybe you just can't square CG with other cases, save to the extent that they're pushing the law along a bit. And they are creating derogations and exceptions where perhaps none existed beforehand. They've decided now is the time to create a carve-out of some description.
Well, they want to push the law along a bit in CG, but they didn't push it along by saying we need to look at whether the Article 21 right is being made effective, and therefore that's why the Secretary of State is applying Article 21. That's
There's much difference between exercising it effectively and exercising it in a dignified way, given that it's being expressed as a fairly basic, low-level standard dignity. I mean, is there much difference between the two?
Well, there is, my lord, in circumstances where it simply hasn't been open to anyone to argue that their right of residence was not effective without social security benefits to which they weren't otherwise entitled.
That no one went into the fact. No one said, I can't even afford a ticket back to my home jurisdiction because I have £20 in my bank and nothing else. And this case is different, and so was AT. So it's not surprising the courts then engaged with the issue and said no more than that which we have through the common law duty of humanity or through Article 3 of the Human Rights Act. So, I mean, I do wonder why we're spending so much time on where the rights come from. It's just what they mean.
Well, Lord, I certainly accept that the precise details of the resources of the claimants in Dano, Mirga, etc., weren't gone into. I think Mr. Samit was destitute. But my point at this stage of the analysis is to question whether the Upper Tribunal's reasoning on interpreting or, as it said, applying Article 21 in deciding a claim for benefit. And my learned friend's paragraph 39b goes well beyond what the Upper Tribunal actually decided and seeks to provide some supporting reasoning, again without authority, by arguing that, well, this might all be about limitations and conditions on the UK in terms of limitations and conditions that it can impose upon rights of residence with reference to Article 30. Again, no authority, limitations and conditions, the reference is to a well-worn phraseology in EU law, and the limitations and conditions which bind the member state specifically are dealt with in Article 13.4, not Article 13.1. So I submit this simply isn't, and the Upper Tribunal was wrong in its reasoning in saying that this was a case of applying an Article 21 right in deciding the claim for benefit, and that is evident from the unorthodox, even heretical reasoning which they have adopted to get to that conclusion. Lady, I'm afraid I'm not entirely sure whether you're sitting to 4:15 or 4:30.
How are we getting on?
So I have a short submission to make on the Upper Tribunal's alternative ground for finding that the Charter was applicable, Article 4.1. I can certainly do that in 5 to 10 minutes, so we would finish by...
That would be the end of ground one.
The end of ground one.
Well, should we do that then? Is everyone all right to sit? Anyone's got childcare arrangements or anything that we need to think about? Right, then let's do that, please.
So Article 4.1 is dealt with in the Upper Tribunal at 108 to 110. And the reasoning, and you you could perhaps have Article 4.1 open in front of you, 209, or the authorities bundle. The provisions of this agreement and the provisions of union law made applicable by this agreement shall produce in respect of, and in the United Kingdom, the same legal effects as those which they produce within the Union and its member states. Accordingly, legal and natural persons shall be able to rely directly on the provisions contained or referred in the agreement. The Upper Tribunal's reasoning was that Article 4.1 was intended to bring about reciprocity of legal regimes, legal rules, as between the UK and the member states. That's paragraph 108 at the end. And that the member states would in future clearly be obliged to apply the Charter and fundamental rights when acting in scope of the agreement provisions referring to EU law. And that's paragraph 110, relying on the Western Sahara case. So because member states were clearly going to have to apply the Charter in dealing with the UK citizens in the future, so must the UK. And we say that is wrong for these short reasons. Firstly, Article 4.1 is not about reciprocity of legal regime or legal effect. Article 4.1 is ensuring that the provisions of the agreement have the necessary legal effect in both the UK and the member states by direct effect and otherwise. What the tribunal said about that submission, paragraph 108, second and third sentences, is that that doesn't account for the word accordingly at the start of Article 4.1, and the tribunal seems to have thought that that's the bit of Article 4 that deals with direct effect. So then what is the first paragraph of Article 4.1 doing? Question the tribunal. We say there is an explanation for what the first paragraph of Article 1 is doing, which is implementing what is Article 288 of the Treaty on the Functioning of the European Union, which is the provision that creates and confers certain legal effects on regulations, directives, decisions, and so forth. And this is my additional authority, a brief extract from a recent ruling of the Supreme Court, which touches briefly on Article 4.1.
Have all the parties had copies? Thank you.
Do you want to have?
Thank you very much.
So this is the recent case about the legality of the Northern Ireland Protocol. It's paragraph 61 in the judgment of Lord Stevens on page 472 of the report, where he sets out Article 4.1, and he says, in this way, the withdrawal agreement makes provision for its direct application in union law and in domestic law. It also makes provision for legal or natural persons being able to rely directly on the provisions of the withdrawal agreement in certain circumstances. So, for Lord Stevens, the first paragraph of Article 4.1 is the agreement making provision for its direct application in union law, which is separate from making provision for direct effect. And I've put as the final page in that clip Article 288 of the TFEU, where you'll see, for example, at the bottom of the page, a regulation shall have general application, but in its entirety and directly applicable in all member states, but a directive shall be binding as to the result to be achieved, etc. So different types of legal effect for different types of EU law. And we say, and I appreciate not a detailed discussion, not an issue in Ray Alistair, but we say there is an explanation for the first part of Article 4.1.
Sorry, I think I'm not getting the point. Why does the first part implement 288?
Well, because...
And only 288?
It provides for the withdrawal agreement to have legal effects, and the agreement and the provisions of union law made applicable by the agreement.
It's
So
not
a
legal
provision
effect,
of
it's the same legal effects. That's where the symmetry and reciprocity comes in, to ensure that it's the same legal effect.
So a provision of EU law in a regulation will have the effect under Article 288 in the member states in any event, and Article 4.1 is requiring the UK to make the same provision. For example, I take the example of a regulation, but that's different from direct effect, which is the second bit of Article 4.1.
Well, the second one, I think, is an example of the first. I mean, the word in particular suggests...
Well, accordingly, I mean, we...
Shall in particular be able... And isn't that just one aspect of equivalence or reciprocity, is that everybody has direct effect, even though it's an aspect of EU law, and in a sense has to be recreated into domestic law.
But there are other instances which are those dealt with in Article 4.1, and I've given you an example of Article 288 of the TFEU. But we say, and my lady, we say that the equal application of the agreement as between the UK and the member states is promoted not by Article 4.1 but by Article 4.4. The provisions of this agreement referring to union law or concepts or provisions thereof shall in their implementation and application be interpreted in conformity with the relevant case law of the Court of Justice of the EU handed down before the end of the transition period. Now, insofar as the Upper Tribunal thought that other member states were going to be applying the Charter in the future because of CG, we say that is not correct, because Article 4.4 draws the line at cases handed down before the end of the transition period. Now, there's a specific extension for the UK, as you...
Well, Article 89
Article 89
makes those words include a reference made before the end of the transition period for which a judgment occurs afterwards.
for the UK,
Is it just for the UK? But that's what 89 says.
yes.
Shall be in binding it.
Yes,
Well, it wouldn't.
and it refers back to...
Would it have any relevance in the rest of the EU? Is it only, you only need to make that provision for the UK, don't you? In any event, it still applies in the UK.
Well, but under the withdrawal agreement, Article 4.4, member states applying the withdrawal agreement do it on the basis of EU law as it stood at the end of the transition period. Future Court of Justice judgments under EU law are not relevant to EU law as it stood at the end of the transition period.
Yep.
Specific extension for the UK in Article 89, referring back to Article 86 and 87, which are also about UK cases. So far from the Upper Tribunal ensuring that the UK keep up with the more expansive and generous treatment by member states in the future, what the Upper Tribunal's reasoning does is to bind the UK to a CG, it thought, compliant interpretation of EU law, which the other member states aren't bound by, because it was handed down after the end of the transitional period. Milady, I'm coming to the end of my time. There are just two things I need to do. The first thing, I'm not sure that I said in terms or clearly made our submission in relation to CG that even if I'm wrong about the effect that CG has on its own terms and its meaning on its own terms, there is a very real difficulty in applying CG after the end of the transition period at a time when EU citizenship no longer applies in the UK. And that is because paragraphs 87 and 88 of CG, the key paragraphs on implementing the Article 21 right, are foursquare founded on the rights of union citizenship. See paragraph 88, which I did mention earlier, referring back to paragraph 62. So we say that whatever else we may be right or wrong about, the reasoning in CG simply doesn't read across to a post-citizenship context. And the final thing I wanted to do was we took the view that the critical part of my learned friend Mr. Delamare's skeleton argument was paragraphs 33 to 39. That really grapples or tries to grapple with the Article 4.3 issues. We've put together a note which sets out his paragraphs and then sets out in just brief bullet points why we say he's wrong.
You know, we have had a lengthy skeleton argument and half a day of discussion about it.
Well, Melody, we thought it would be a convenient aid memoir. I've said quite a lot of it, but it just collects it in a.
And has everyone had a copy of it?
I have.
No.
Well, it's part of my submissions to the court.
Well, it's you're purporting
if
to put
Lady wishes to have that.
What you're asking is to put in a sort of a supplementary note, written submissions.
Well, what I'm asking to do is, and you may say you wouldn't find it helpful, but is to respond directly to those paragraphs in bullet point form. We haven't put in a supplementary skeleton. I'll try to.
We'll. I don't want it at the moment. Perhaps Mr. Delamere ought to read it, and but
I have to say, my lady, the trouble with a document like this is, what is the case then that you have to answer?
well,
I
mean, an application could have been made for a supplementary skeleton argument.
Well, I object, my lady. It's far too late.
If it's not helpful, it's not helpful.
Very well. I'll leave it at that. Thank you very much indeed. So, have we completed ground one then? Thank you very much indeed. I hope you didn't feel under too much pressure at the time. I'm very glad. So, on to the other grounds in the morning. 1:30. Thank you all very much.